There are multiple kinds of theft crimes. To commit the theft crime of robbery, you must steal something using force or the threat of force. But what does it mean to use force to steal something? The court explored this question in State v. Keeton. Larry Keeton gave money to a convenience store clerk to buy cigarettes. When the clerk opened the cash register, Keeton reached across the counter and took cash from the register's drawer. The clerk ran to one of the store's double doors, where she tried to block Keeton's exit with her body and grab the cash from Keeton's hand. The clerk made contact with Keeton's hand, but wasn't able to get the money. Keeton attempted to exit through the other door, but the clerk moved and blocked that door with her body. Keeton backed up a few steps, then gestured to the clerk by extending his hand with the cash and walking toward her. At that point, the clerk stepped away from the exit. Keeton pulled his hand back to his chest and exited the store. As Keeton passed the clerk, she grabbed his hat out of anger. Keeton was charged with robbery for committing a theft involving an assault. During a bench trial, Keeton testified that he never intended to touch, hurt, insult, or offend the clerk. However, on cross-examination, Keeton admitted that he would have pushed past the clerk if she hadn't moved from the exit. The clerk testified that she moved from the exit because she realized Keeton was determined to leave and she couldn't stop him. The trial court convicted Keeton of robbery, which included an implied finding of assault. Keeton appealed to the Iowa Supreme Court, arguing that the evidence didn't show that he'd committed an assault during the theft.